I call Richard Prosser.
Thank you, Mr. Speaker. It's always a pleasure to follow my erstwhile friend and colleague from the Primary Production Select Committee from the Green Party. And he has that wonderful ability that the Greens have of being able to support a bill but do so very, very grumpily. So thanks for that, Mr Browning. I know it's early in the morning. Mr Speaker, I'm very pleased to rise on behalf of New Zealand First to take a call in the second reading of the Geographical Indicators Wines and Spirits Registration Amendment Bill. New Zealand First supported this bill to the Select Committee, and we continue to do so because it is a necessary piece of legislation for the wine industry and for New Zealand's international trade. But I do have to flag at this point, Mr Speaker, that our support for the bill might not continue beyond the Committee of the Whole House. And I give that indication because of a clause that has found its way into the bill, to which New Zealand First finds that we are diametrically opposed, Mr Speaker. And as with so much of this government's legislation, as with too much of this government's legislation, it's a clause that makes special reference and gives special preference, yet again for no adequately explained reason, to marry on the basis of race. And that's a great shame, Mr Speaker. It would be a great shame if New Zealand First were forced to withdraw our support for a bill which we acknowledge is a necessary thing for the wine industry. Listen and learn, Mr Turikatne. You will understand. I will explain. And for New Zealand's international trade, both imports and exports of wine and spirits with the rest of the world, particularly to Europe, because of a clause that the government has decided to include in it, which is not only entirely unnecessary, but which is actually counterproductive in a number of regards. And it's counterproductive, Mr Speaker, in that not only is it yet another example of the promotion of separatism, but at best it could be seen as paternalistic and insulting to marry. And members on both sides will doubtless argue that yet again, here's New Zealand First being racist again, here's New Zealand First indulging in marry bashing, the same tired old inaccurate excuses that they trot out for supporting political correctness. Every time New Zealand First stands up for one franchise and one people, one united people and one law for all. The thing is, Mr Speaker, that marry is an official language of this country, and it shouldn't need that kind of special recognition that it somehow needs this kind of paternalistic help and support. It's insulting, it is derogatory, it doesn't need this special justification. So, Mr Speaker, the clause 21B is the offending article that has raised our ire. It will insert new section 39A, which is proposed. It will read, "It is a function of an advisory committee appointed under section 177(1) of the Trademarks Act 2002 to advise the registrar whether the use of a geographical indication in relation to wine or spirits or the registration of the geographical indication is or is likely to be offensive to marry." And the explanation given for the reasoning behind this proposed change, Mr Speaker, is that, as is recorded in the report of the Select Committee, whilst the bill, as it's introduced, provides that the registrar must not register a geographical indication if its use or registration is deemed offensive to a significant section of the community, including marry, the bill doesn't specify who the registrar should consult to determine whether or not the registration of the geographical indication would be offensive to marry. And that's true, but by the same token, neither does it specify who or whom the registrar should consult in order to determine whether or not any given geographical indication might be offensive to anybody else, or more specifically, anyone we presume who isn't married. And I will come back to that point, Mr Speaker, but it's worth remembering at this point, I think, that we're dealing with geographical indicators here. And this bill deals with geographical names and features that might be or are associated with wine labels and the production of wines and spirits. We're not talking about words or phrases or cultural concepts, and for those who might argue that, or to some merit at least, in some situations these may well be one and the same, it's essentially place names and names of geographical features that are already in use, and it's difficult to see how their inclusion on a label could be offensive to anybody. There are already provisions in the law allowing such names and words and wording to be removed from official use and recognition if they are deemed offensive. And indeed, the Geographic Board is undertaking just such an exercise right at the moment. With regards to some names which, whilst they might reflect a period of this country's history where certain nomenclature wasn't considered offensive by a large majority of the country at that time, they're no longer considered to be so. There is a place in North Canterbury, Mr Speaker, which is named and officially gazetted as Nigger Hill. And that's plainly no longer acceptable in terms of the values and mores of modern New Zealand, and it's going to be removed, and rightly so. I don't believe there's a single rational person in New Zealand or a member of this House who would disagree with that. But that's a decision of the Geographic Board, Mr Speaker, and not, we believe, should be a function of the Advisory Committee to the Registrar of Trademarks. So if a name or a feature is deemed acceptable for use as a place name, then surely it should be acceptable for use on the label of a wine or a spirit that's associated with that place or feature. Or so perhaps the Maori Language Commission could be consulted if there's any perceived offensive potential in the combination of certain place names with certain products, though once again, because it's going to be established and gazetted names of places and features that will be registered, it's difficult to see how such an offence could be caused. So, to return to my earlier point, Mr Speaker, this proposed new clause doesn't make any specific reference to any significant section of the community who might be offended other than Maori, and that's plainly racist and separatist, and it is insulting and derogatory to Maori. We need to be mindful that this bill deals not only with our own registration of geographical indicators for New Zealand wines and spirits, but also it deals with this country's recognition of the registered indicators from other parts of the world from whom we import such products. On that note, Mr Speaker, there's a place in Australia that goes by the name of Chinaman's Knob. And that may or may not sell more wine, but it could well be seen as being offensive to any number of people in this country, Mr Speaker, if it were to appear on a bottle of imported Australian wine. And yet we've made no provision in this bill as to who the registrar should consult on that matter. The New Zealand Gazetteer on the LINZ website, in fact, lists all sorts of officially recognised and presumably acceptable place names that could be offensive to all manner of people, Mr Speaker, and knobs feature quite heavily. There's a Scots knob that might offend people of Scottish heritage, or it may well persuade them to buy more of the stuff. There's a Richards knob, Mr Speaker, and I myself might choose to take offence to that. But the bill doesn't make any special mention of a body to be established or consulted in terms of asking me whether I object to that or not. But my point really is, Mr Speaker, that we don't regard this as an insurmountable obstacle. Agencies that already exist could be utilised in order to satisfy the requirement that the registrar, quote, must not register a geographical indication if its use or registration is deemed offensive, without requiring another inspection of every application by yet another agency, presumably requiring the payment of yet another fee, Mr Speaker. And further to that, a colleague of mine suggested that we could go one step further and require that any such agency that is going to undertake that activity should make up a list of words or names that might give offence and the reasons for that before any such application is submitted, so that both the applicants and officialdom would have some guidelines to work with. My colleague suggested that in similar circumstances, references to things that are sacred, perhaps names of gods and so forth, might come into play. But again, we're not talking about those sorts of cultural concepts. We are talking about place names that are already in use, that are already deemed acceptable. And it's unlikely that anything outside of those parameters would find their way onto a wine label. And if they were to do so, Mr Speaker, it's more likely actually that that sort of thing would probably be outside the scope of this bill. So we will be proposing some changes to the bill when it comes back to the Committee of the Whole House, Mr Speaker. New Zealand First will be introducing supplementary order papers to either scrap the proposed inclusion of new clause 21B and section 39A altogether, or to perhaps replace the proposed use of the Advisory Committee for the Registrar of Trademarks with the oversight of the Geographic Board or the Maori Language Commission instead. And to suggest, as I say, that whatever agency finally is settled on, that they come up with a list of names and words and phrases and so forth first, against which applications can be measured, so that we do avoid the potential for any offence being caused, and also so that we avoid the requirement for people paying unnecessary additional fees. And we do hope that the government will take a genuine objective look at these proposals that we will bring forward, Mr Speaker. But in closing, I reiterate that we do agree that in all other regards this is a necessary bill. It's long overdue in some aspects, and we support its passage through the House at this stage. Thank you very much.
And now Todd Barclay.
Thank you very